Morning, everyone. Thank you so much for joining us today. Thank you for being a part of and attending our next part of our LinkedIn series, following on from our previous LinkedIn series based around the changes to sick reform. Just giving an intro, I'm Sundeep, so I specialise in HR recruitment across Northamptonshire and Milton Keynes at the One Group. And this is Emma. So hi, Emma. Thank you
Hi.
for joining us. Emma, are you okay to give a bit of an intro to anyone new that's joining?
Yeah, absolutely. So my name's Emma. I run a business called Gateway HR. We're based in Corby, but work all over the UK, mainly helping kind of micro, small and medium-sized businesses with all things people. That's our kind of strap line. So I've worked in HR for about 22 years now. So I like to think there aren't many things that I haven't seen or come across. And when there is, having worked in the profession for a long time, there'll always be somebody that I could maybe pick their brains off and then come back to people.
Amazing. Thank you so much, Emma, and thank you for joining us again.
Yep, no problem at all.
So today's LinkedIn Live is based around the legal changes to dismissals. So I guess initially starting off, Emma, what would you say and sort of summarise that employers need to know in regards to that at the moment? What are the key elements?
Yeah, I mean basically the fundamentals that have been in place for decades are not changing, but some of the requirements are, which we'll come to. So it's really thinking about the danger of unfair dismissal, which is the main kind of legal side, which a lot of people will have heard of, but maybe not understand what goes behind it. So in summary, basically, unfair dismissal really looks at two sides. So as an employer, do you have a fair reason to dismiss somebody in that situation? And also linked to that is have you done it fairly?
Yeah.
Because potentially, even if you've got one of the 5 fair reasons, which I'll go through in a minute, if you haven't done it properly, you could still find yourself in a tribunal. So the 5 fair reasons which haven't changed and are not going to change are conduct. So basically behavior. So if you think about things like misconduct or gross misconduct, that would fit under there. Capability, which a lot of that is around performance. So whether somebody is able to perform in their role, which of course could be that somebody's, for whatever reason, not performing and you followed a fair process and you've got to kind of the end of the road. But of course, a lot of what fits under there is around health, so physical or mental health, that may mean that you've got to that point where somebody can no longer do their role. So that's the two, and probably the most common. So most dismissals, or a lot, will fit under that.
Okay.
Third one is redundancy. So redundancy is technically a dismissal. Certainly a lot of that, sadly, happening at the moment in lots of different sectors. So the dismissal is because the role is no longer there for whatever reason. Fourth one, which is more unusual but does happen, called a statutory restriction. So somebody's unable to do their role due to either a legal change or something has happened. So you always use the example, perhaps somebody's employed as a HGV driver. They lose their license for whatever reason. It might be to do with something to do with the police, or it might be to do with health. So they can't do their job anymore. So potentially that could be a dismissal, unless you can find them a different role. And the final one, it's an SOSR, which is some other substantial reason. So to an extent, basically, if it doesn't fit into one of those 4, it might be 5. But just as a kind of a word of warning, that doesn't mean you can do what you like. And put it within that.
No.
So that's your 5 fair reasons. So if you're in a situation looking at dismissal, it's thinking, right, is it one of those 5? Because if we were challenged in a tribunal, we need to show or demonstrate it's one of those 5. And then the second half, which is as important, is have you done it fairly and properly? So have you followed a fair process? If you have a disciplinary policy, which you should have, have you followed that policy? Because if you haven't, it will be an unfair dismissal. However good your reason is, if you don't follow your policy, somebody would have a potential claim. Obviously, they get a much smaller payout if you've got a very strong reason. But again, you don't want to end up in a tribunal because you missed part of your policy.
Yeah, absolutely. Okay. And from, in your opinion, Emma, what is the best process an employer should follow to ensure a fair dismissal?
Yeah, so all employers should have a disciplinary process, or if it's one of the other reasons, I said about kind of performance and capability in terms of health, it might all be within one policy. But again, if you have separate policies for each one, make sure that it refers back to what happens in the disciplinary policy. So the very basics, which people can find on ACAS, is to at least have a policy that meets what ACAS requires you to do, because that is what a tribunal will look at. They will look at the ACAS guides, and if your policy doesn't meet those requirements, I always refer to ACAS may as well be law, even though it's not, because that's what the tribunal will look at. So if in doubt, if you don't have one, or if you've not looked at it for a long time, do it as a minimum, refer back to ACAS and think, right, do we at least tick all of those boxes within that? But also, and I know I say this every single time, make sure that managers know what they're doing. So if they have an issue, that they're trained and capable, but if not, they know who to speak to, so they don't, for want of better language, they don't go rogue, dismiss people, and then things go wrong when you get that letter from a solicitor or something through from ACAS.
Amazing, brilliant, thank you. And what are the risks, Emma, if an employer doesn't follow the right procedures, the right policies, when it comes to dismissals?
The major risk, which, like I said, most people will be aware of, is that the employee could claim unfair dismissal. So at the moment, which I know we'll come to in a little while, somebody needs to have 2 years service to be able to claim unfair dismissal. So quite often people will say, oh, it's okay, this person doesn't have 2 years service, which is known as a short service dismissal. So if it's under 2 years, and that does mean that, depending on your thoughts as an employer, you could potentially do a shorter process because there's less risk. But we always say to people, there's still risk, because it could be what's known as, and I don't want to kind of bombard people with jargon, but what could be a wrongful dismissal. So if you breach somebody's contract in terms of how you dismiss them, you could still be open to a claim. So perhaps somebody's contract says they have, a specific amount of notice, and you don't follow that. That would be a wrongful dismissal. There are also various reasons that are automatically unfair. Hopefully, most people would know this for the right reasons, but you can't dismiss somebody when they tell you that they're pregnant. You can't dismiss somebody for health and safety reasons. So if perhaps somebody refuses to do something because it's dangerous, and you dismiss them. So there are some things. And then potentially the biggest risk, which people forget about, is if the dismissal is deemed as discriminatory in some way, because that right starts from day one. So yes, they might not have 2 years service. So let's imagine, as we've done before, Sunny, that you're in my team. For whatever reason, I've decided to dismiss you, and I think, well, that's okay, because you've only been with us for 6 months. But you then make a claim to say, hold on a minute, I've got a male colleague or a younger colleague, an older colleague, whatever it might be. They did the same thing as me, and they didn't get dismissed. So therefore, Emma, I think you did that. Because I'm a woman, because I'm a certain age, whatever it might be. And I would probably struggle to defend that. And claims under discrimination or equality are unlimited. So they can be a lot more expensive than unfair dismissal. So we always say there is always a risk. So you're much better off doing it properly. And then, I can never say there's no risk, but there's a lot less risk if you do things properly.
Okay, amazing, brilliant. And what would you say, Emma, in regards to, you just mentioned short service dismissals? from your perspective, what is the best process, and how is the best way to handle short service dismissals?
I would always say start with your policy, because that may well outline what is the difference between the two types. Again, refer to ACAS. Always be thinking, is this fair, regardless of how long somebody's been with us? So look at what's led to this point. If it's around conduct or capability, is this the first the person knows of it? Because we hear that quite a lot. So they haven't been given a chance, to improve. So again, are you being reasonable? Do they have a chance to have their say? So even if it's relatively clear cut, so perhaps somebody who's not been with you for very long and has, I don't know, maybe sworn at a customer or being, or whatever that might be, you've probably got a very good reason, but I mean, that's maybe not the best example, because hopefully most people would know you shouldn't do that. But did they know they shouldn't have done that? Did they get to have
Yes, yeah, absolutely.
Because it might, again, I'm not saying it would justify it, but it might be that if you actually allow the employee to have their say, well, I'm really sorry, I know I shouldn't have done it, but the customer was incredibly offensive to me. I tried my best, and then I'm sorry I lost. Because in that process, maybe you might think, okay, we're going to still need to issue a warning, and if this happens again, it definitely would be dismissal, but on this occasion we'll give you the benefit of the doubt. So or just, again, for the sake of maybe, when I say slightly longer, it might only take a few days longer, but make sure you've covered everything. Because I always say, if you always think, if somebody from the outside is looking in, was that a fair decision, and did you do it properly?
Amazing, thank you. And it's a summary dismissal. So, I mean, what is a summary dismissal, and is it legally justifiable?
Yeah. So basically, a summary dismissal is when somebody is dismissed without notice.
Right. Okay.
But what that means is they don't get the notice within their employment contract. Nearly exclusively, it would be for gross misconduct. So somebody has done something that, definitely they shouldn't have done. Again, that will be in your policy as to what that would be. I say standard, it would be things like, offensive behavior, fraud, all the big things that you would expect to be something that somebody would get dismissed for. What it doesn't mean, which again, sometimes people get confused, is that you could literally, sack somebody on the spot without a process. Because you've still got to have that. Again, it can be relatively quick, because if somebody's done something, awful in the workplace, it's not going to take a huge amount of time to investigate that, because if perhaps lots of people saw it, the person isn't denying that they did it. You have a disciplinary hearing pretty quickly, and then you dismiss, and then the summary bit is you're not entitled to your notice. Whereas if you think about the others, things like redundancy, you do get your notice. A dismissal maybe for conduct that has just continued. Somebody would still get their notice within that. And obviously, well, maybe not obviously, but certainly dismissal in relation to health, obviously people still get their notice, because it's not, it's not something they've done wrong. It's just that's where we've got to in terms of the relationship.
Okay, brilliant, thank you. And how does probationary periods affect dismissals, Emma?
Yeah. So this is something that is probably going to change, which we'll come to. Technically, at the moment, probationary periods don't have any legal standing, but they are still incredibly useful. So we always recommend that employers do it, because if a dismissal in probationary would be a short service dismissal, because a probationary period is not going to be 2 years. But what it enables you to do is demonstrate that you've done something fairly. So if somebody's got a 6-month probationary period, you've met with them at the end of month 1 and said, it's not quite working out, this is what we need you to do better, this is how we're going to help you. Then you meet again in month 2, obviously documenting all of this, and things aren't any better, and at that point you decide to dismiss. should somebody try to challenge it, you'll be able to say, well, no, because we gave them an opportunity. Here's the documentation. So coming back to that example, when I've dismissed you, Sundeep, if I'd done it properly and I've got notes to say it's because you're not doing your job very well, you could still try and say you've done it because, but I would say, no, I haven't. Clearly demonstrated, we gave you every opportunity to respond. So really, really important. And again, I know today we're talking about dismissals, but you take somebody on because you want them to be successful for them and for the organisation. So if you have a probationary period, you can address any issues early on. Probationary periods go both ways. So again, in our fictional employment relationship, Sundeep, you might say to me, I'm not really enjoying this as much as I thought I would. And then we can have a conversation, and hopefully I can help kind of turn that around. Maybe, I can, find you some more interesting work to do, or whatever that might be.
Amazing. And what would you say, Emma, the key considerations should be for an employer when dismissing based on conduct and capability? What are the key aspects?
Both of those is making sure that everything is very clearly documented. So particularly for conduct, to carry out a thorough investigation, which thorough may not take long, because I know people think, oh no, this is going to be really long-winded. But again, thinking actually that's much better than ending up in a tribunal. So really find out what's happened. Ideally, always difficult in a smaller business, but somebody to do that investigation who's not been involved until this point. So, kind of fresh pair of eyes, not involved in this situation. An investigation is really, as it sounds, what's happened. What's happened, who did what, were there, if it's relevant, any witnesses, if it's around conduct, unless it's really obvious, are we sure the person knew they shouldn't have done that? So hopefully you might look at, yes, they've done their induction, it's covered in the induction, they've done the relevant training. Perhaps there've been some informal discussions where a manager has said, you need to not do that, or you need to do that better. Whatever that might be. And then kind of the conclusion of the investigation is, does this need to go further in terms of disciplinary hearing? So an investigation doesn't make a decision, because at the end of an investigation, the recommendation might be, this is not a disciplinary issue, this is a training issue. And that's what we need to do. If it becomes a disciplinary issue, then it goes to a disciplinary hearing or meeting, depending what your language is. And that's where then somebody else will make the decision. Is it about a warning? Is it dismissal? Again, at that point, that person, of course, can disagree with the recommendations and say, no, I think, having gone through it, this is, I say, just a training issue. So the disciplinary ends at that point, but then obviously make sure you actually do the training that's needed.
Amazing. Brilliant. And what's the difference, Emma, between an unfair and a wrongful dismissal?
Yes. So unfair is that you've not met either of the two tests. So it doesn't fit under one of the 5 reasons.
Right. Okay.
So one of the things that we hear a lot, and if we're able to, obviously, then say to the person, don't do that, is when an employer wants to call something a redundancy, but it's not. So sometimes employers, rather than have a difficult conversation around maybe performance or conduct, will say, well, we could just make this role redundant. And that's, depending on the circumstance, not a genuine redundancy. So you would fail at that first point, because a tribunal would say this was not redundancy. Because nobody else, if relevant, nobody else. So it doesn't fit one of the 5, and that you haven't done it fairly. So that's unfair dismissal. And like I said, at the moment, people need to have 2 years service to be able to claim that. Wrongful is basically where you've done something that's breached their employment contract. So if there's a certain notice period, and you don't give that, if unless it's a summary dismissal, if somebody is dismissed and then you don't pay holiday pay that they're entitled to.
Right. Okay.
So it's almost like what else have you done wrong within
Yes.
that process? And it shouldn't be, but always check somebody's contracts, because if they're not well written, perhaps even something around disciplinary or dismissals is in the contract. So again, if you don't do that properly, it shouldn't be. It should always be in a handbook. But again, I've read some interesting contracts over the years around what's included. So always have a good look at that to make sure you're not going to do anything wrong.
Brilliant. And in regards to ACAS code of practice, what part does that play in dismissals?
Yeah, that plays a really important part in terms of if you have a policy, that it needs to at least meet those standards. If you were in a situation where there isn't a policy, to at least follow that. So and to be honest, in 22 years, I've never had to do a disciplinary where there isn't a policy. But if that was the case, and one can't be created, it would be to refer to that. So in relevant documents or meetings, to say that we're following the ACAS code in terms of what we're doing, because of course some small employers or new employers may not have got all that in place yet. But of course you can put a policy in place. The only thing that would be difficult is if you're relying on something within that policy, for example, for gross misconduct, and the person might say, well, I didn't know that because this policy is new.
Right. Okay.
But that would be, like I said, that would be very unusual. So anybody who's watching today, do check that you have that policy in place, and that people know, where it is. Have they read it? And if relevant, have you got proof of that?
Amazing. And Emma, in your opinion, what's the best advice for employers to minimize the risk of tribunal claims when dismissing someone? What would you say is the key points to ensure?
The main ones would be, again, make sure that managers are good managers, so things don't go beyond where they should do, because most, not all, most issues can be dealt with initially from an informal point of view. So once as a manager you've got a little bit of concern about somebody's conduct or capability, that people know what to do, so it doesn't get to the point where maybe a rash decision is made and nothing has happened in between. Have a policy and make sure that you follow it. And always, because there are risks, always take advice. If you're not sure, take advice. If you've got a HR team, you would speak to them. If you outsource your HR, because we always say, for us with our clients, we would much rather you ask before you do something. Because this is well, I don't mean we dismiss people for a living. That's quite grim. But employment is what we do. So we might know something, because this is what we do day in, day out in terms of advising. So, just to take that advice before you do something, because once you've done it, there's no going back.
No. Amazing. And what is the importance, Emma, of appeals in the dismissal process?
Appeals are really important because that's part of the ACAS code. So make sure it's in your policy. Make sure if you do make a decision to dismiss, or equally to issue warnings, that in the follow-up letter that would go to the employee, that it's detailed within there. Depending on what's on your policy, how do they appeal? So who do they appeal to? An appeal, it sounds obvious, but there has to be a reason. And the employee has to state that. So it can't be as simple as, I didn't want to be dismissed, because probably most people don't want to. The appeal needs to say, I'm appealing because, you didn't take this into account, or I didn't think it was fair, or whatever it, basically there needs to be a reason. Who would hear it, which needs to be somebody, again, always more difficult in a smaller business, but somebody who's not yet been involved. So that fresh pair of eyes. And there will always be time frames within there. So the employee will only have a certain amount of time to appeal. depends what's in your policy. 5 days or 5 working days is kind of standard, and that as an employer, you will, deal with that appeal, as soon as you're able to, because depending how complicated it is, it might be relatively quick. It may not be. Really important, because again, if you don't allow an appeal, that could potentially make it unfair. But also from the other side, with employees, if an employee goes to or wants to make a complaint to a tribunal, a good solicitor will say, well, you need to appeal, because a tribunal will say, well, you didn't, kind of the language is you exhausting internal processes.
Yes, okay.
Because if they had appealed, the outcome may have changed, and we wouldn't be. It doesn't mean they wouldn't be allowed to go forward,
No.
but it would potentially kind of stack against them a little bit, because of course, as an employer, you could say, well, if they'd appealed, we would have looked into it, but they didn't.
Right.
So
Okay.
really, really, really important part of the process for both parties.
Brilliant. Thank you. And Emma, what would you say is summarising the upcoming legal changes to dismissal procedures for 2026 and 2027?
Yeah. This is probably the one that got the most kind of media attention when it first kind of emerged a little while ago now, and it has since changed. So the basics are, like I said, the 5 fair reasons and the process, etc., is not changing as far as we know. But what is set to change is the 2-year, and that's what has caused a little bit of panic with employers. So at the moment, it's looking like it may go down to, well, originally they said it may become a day 1 right, which is what caused panic. So, somebody potentially could make a claim. At the moment, it's looking more likely to be a year rather than 2. But what did happen where are we now? Yeah, July, I think it was, but don't quote me on that. The latest is that it's now being pushed to 2027. So it's longer before it happens. And there's still quite a lot of debate of what that would look like. What is probably, and I know this is frustrating to people listening, but until the government decide what they're doing, we can't say definite. What is looking very likely is that probationary periods will then actually become part of law.
Oh, wow. Okay.
So it will be standard to have. Again, how long that probationary period might be is going to be, again, we have to wait and see. So as what we're saying to everybody really is, yes, it's now 2027, but actually, if probationary periods are very useful anyway, regardless of the law, this is your chance. If you don't use them, or you don't do it properly, make that a normal way of working, so that whatever happens in terms of the law, it's not like, oh, we don't do that. And again, make sure that managers know what they're doing, within that process. So it's very much an open book at the moment, but I would say in summary, the qualifying period will go down. By how much, we don't know. So relying on the 2 years will lessen, and that most likely probationary periods will have legal standing. So if you don't already use them, which we always recommend anyway, make that a normal way of working, so that when the law comes in, we personally, I don't think it's a huge issue, and I know people are worried about it, but if you follow a fair process and do the right thing, most of the time you shouldn't have anything to worry about.
Amazing. Thank you so much, Emma. Thank you so much for joining us, and thank you to everyone else for joining us as well. If there was any questions or any advice needed, feel free to contact Emma directly or myself, and we're all happy to help from our end. The next part on our LinkedIn Live will be a Q&A to run through our different sessions if anyone's got any questions or any particular scenarios, etc. If you are interested, feel free to contact us directly. Please do remember to like our LinkedIn page at the One Group to be kept up to date in regards to any further events that we have taken place. But thank you so much, Emma.
It's no problem at all. It's a pleasure. Thank you.
Thank you. Thank you.